morning. This is a specific meeting being held for the deliberations of appeal of a hearings official decision, Braywood Hills 3rd Edition, Phases 5 and 6 PUD, City File PDT 18-4. And this is the City of Eugene Planning Commission. We do reserve 10 minutes at the beginning of all meetings for public comment, but the public comment cannot be related to this project or any other projects that are currently in deliberations. And I don't have my script in front of me, so can you help me out, Lauren, if you want to be clear?
That's accurate. So the record for this application has closed. So the Planning Commission will not hear any new evidence or argument related to this application. If there are members of the public present who want to talk to the Planning Commission about issues outside of the issues related to this Braywood PUD application, that's available.
Perfect, thank you. So if you do want to speak, there's screen sheets, but don't feel like you have to fill it out right this second. If you want to speak, you can come up and speak. Just fill out a form afterwards. Just state your name and your address, and then just make sure you fill out the form and leave it with staff before you leave. So it sounds like we have one person from the public. Okay.
I didn't expect this opportunity, but I'll be brief. My name is Larry Smith, and I'm at 3325 Vadera Drive. I'll speak about some general issues which I did not speak of during the last testimony because it was not appropriate, but these are regarding policy changes or regulatory changes that the city needs to clarify, and they're only attached to this issue in the sense that I believe they made this a very confusing process to go through in some regards because they're not clear with regard to the city's regulations concerning land use. And I don't have my slide in front of me, but if you didn't tear it out of your packet, you might be able to pull it out of that, but I'll just cite it by memory.
I think what would be helpful is be really clear, let's not talk about this particular and stay kind of clear about your feedback. It should be noted I specifically
did not talk about this during, in behalf of this.
Great, so
So in general, the issue I have is the question of definitions. I noticed in going through our land use regulations there, I could not find a formal glossary that would have clarified the definition between excavation and grading. Those things should be dedicated to a definition somewhere in the code, especially when there's questions that come up on jurisdiction and interpretation and trying to find other sources for generally used terms. You know, you'd think that there wouldn't be that much confusion on a Latin-based language interpretation of terms, but that gets in the way sometimes. And I think this commission and the public have spent a lot of frivolous time arguing over a ridiculous proposition because of definitions not being clear. So that's the one input I wanted to make.
Perfect.
And then the second major point is with regard to properties, and you'll encounter probably more of this rather than less because I think we're at the point where many of the undeveloped sections of land within the city are undeveloped for a reason. And that reason is typically that they're expensive, they're difficult, they're generally conditions that have some sort of features that either make them illegal to develop the way the developer wants to or financially difficult for them to do that. And so in specific regard to the wetlands, I'm sorry, the stormwater management plan. Now the city's done a great job in putting together a manual to be used in estimating the amount of extra runoff that's going to come from development. If you look through the manual, it's got many different ways of calculating, gives people flexibility for calculating how you determine how much capacity you have to provide for when you have to treat the stormwater. I'm very happy to see that the city does put restrictions on with the intent of controlling peak runoff and to keep erosion down. I mean, it's just great. All of those, the intent behind the regulations are very good. What I find lacking, though, is it only treats the incremental flat impervious surfaces added when a development is made. So in other words, if you turn a little grass area into pavement, okay, there's a square footage you're converting, making impervious, and therefore you need to figure the amount of water coming off that pavement. Or if you're adding a house, you need to figure the roof of the house and figure out how much area it's going to take and how much extra runoff you're going to get from that impervious surface. There are cases where that would be used in a subdivision for figuring out how much the street that's going to be added is going to increase the peak runoff. And the unfortunate thing about that is there's nowhere in that manual or in the regs that require that any accommodation be made for such things as slope. And we all know that when it comes to peak, the term itself is rate of flow. And so when you got a steep slope, you're going to have higher velocity. And so your peak runoff is going to always be higher in a slope. And it also doesn't accommodate existence of natural treatment facilities. Because when you have a wetlands, for example, and you're removing that wetlands, you're not just removing it for all the things that people get upset about, wildlife and flowers, and, you know, everybody likes wetlands, going by them. But there's a very practical reason to be concerned about removing those wetlands, and that has to do with the storage capacity that they offer. And they mitigate the peak flows by literally being a pond in the soil to gather that water, and it meters it out much more slowly, so the peak flows are reduced. And that would seem like a fairly obvious thing to, in fact, in many cases, these are both bigger factors than any addition of driveway or roofs. The removal of existing treatment and the steep slopes are both factors that need to be considered in your stormwater management. So I would encourage you to look and consider the different properties that need to be, or that will probably be coming before this commission in the future, and determine whether this is going to keep coming back and back again, and create a dilemma for the city in trying to administer your policies. So those are my comments for input for improvement of the process. I'll make one more. I meant to make one more, and that is regarding stormwater as well. The city has a position right now that when it comes to evaluating applications, that the planned use, the planned unit development application process itself does handle the question of stormwater, but it's become policy within the city to defer any consideration of the specifics of stormwater plan to a permitting phase. Now, I believe that's unfair to everybody. It's unfair to the developer because they would dedicate a plat with boundaries that have been decided upon and will not have had to explain globally how that whole development is going to handle stormwater adequately. And when it gets to the permitting process, you know, guess what? There's an issue because, you know, you make an argument they needed to have an area set aside in the development for stormwater and not just relegate it to each of the individual lot owners, which some applications will leave it up to the individual property owners to deal with their stormwater. So the policy of not requiring a complete stormwater analysis during the subdivision phase when the lot lines are set is a mistake, because it puts the future owners of those lots in a bind, because collectively they may have an issue, and how are they going to meet it as a bunch of lots rather than one development? It may be impractical, more expensive, and it'll prolong the process. So I would encourage you to consider having a little bit, especially on steep properties, especially on properties with these extra features like wetlands, to make sure there's a thorough stormwater plan before you go through the PUD approval, and not put it off until the permitting process to raise the fight during that time. So, okay, those are my inputs. I hope those were clear. I wasn't prepared with my notes, but thank you very much.
Thank you. Did you want to? Okay, great. So we'll move on to the deliberations. Thank you. And I'm going to start by letting Lauren explain, because we're going to address some of the testimony that was received. If hopefully you've had a chance to review the final order. So essentially what we're going to do is, and for the public, we're going to use the final order just for an organizational piece in terms of how we're going to move through the meeting. And for the public and those in the audience is if you, because that actually hasn't been released to the public for them to access right now, is if you go to the hearing night of Tuesday, June 18th, if you go to the website, the AIS, so the organizational, the agenda item summary, it's very similar. The information and organization is similar to the final order. But in terms of us today and how we're going to walk through it, if we have reference to page numbers, et cetera, please use the final order. And if you need a copy, staff has a copy. Yeah, Commissioner Borowski.
Chair Taylor, would you refer to it as a draft final order?
Of course, yes, thank you.
Just
Yeah.
to be clear.
Yeah, thank you.
No final order has been
Yeah,
written.
no, thank you. So it is, thank you, Commissioner Borowski. It is a draft. We have not made decisions yet. We're here, deliberations today, and then if needed, we have a follow-up tomorrow. So it is a draft. It's just organizationally, we're going to use the draft. Okay, Lauren.
Thank you, Chair Taylor. So there are a couple of quick procedural issues that I'm going to take you through. First of all, I just want to point out for you and for those that are listening at home that the record in this appeal has been physically placed before you. It's in the cart over there, and it's also been provided to you electronically. That during the public hearing, the applicant requested the opportunity to make some procedural objections to some of the evidence and argument presented at that hearing. And as of 3 minutes before this meeting, I had not received anything from the applicant on that matter. I don't believe that planning staff has either. So the discussion of new evidence that I'm about to take you through is based on planning staff going through the record and determining whether some of the submissions that came in during the public hearing included new evidence. Nick, can you pull up the definition of evidence for me? So, as you know, having gone through this process in other applications, because this is an appeal from a hearings official's decision, Planning Commission does not consider new evidence during the appeal process. You are limited to consideration of evidence that was also available to the hearings official. And here is the definition for, in case it's helpful, of evidence both in the City of Eugene Land Use Code and it's the same definition from the Oregon land use statutes. So evidence constitutes facts, documents, data, or other information offered to demonstrate compliance or noncompliance with the standards believed by the proponent to be relevant to the decision. And then the other piece to consider today is because, again, this is an appeal from a hearings official's decision, our code says that the appellant has to identify the issues that they are appealing, and then the Planning Commission is limited in its consideration to the issues identified by the appellant. And there were some arguments made during the public hearing that strayed outside of the scope of the issues identified by the appellant. And we treat new evidence and argument outside the appeal issues a little bit differently. New evidence, I will ask Planning Commission to explicitly reject, assuming that you agree with staff that it is new evidence. So we'll need a motion to do that. Arguments outside of the scope of the appeal issues, you don't need to explicitly vote to reject in the same way, but you should not consider them because the scope of your deliberations is limited to those appeal issues identified by the applicant. So there are two pieces of testimony that came in during the public hearing that staff believes contain new evidence. The first one is written testimony from Julie Butler, and it contains 7 photographs, none of which were previously included in the record, and so all of which staff believes to be new evidence. And so our staff's recommendation is that you reject those photographs, and when we transmit, assuming that there is an appeal of your decision, when we transmit the record to LUBO, staff will redact those photographs from the record. And so you will not consider them as evidence in making whatever decisions you make on this application, should you decide to reject them.
So would someone like to make a motion for this first? We're going to break it up into two.
I will make a motion that we reject the photographs submitted by Mrs. Julie Butler at the public hearing.
A second?
Yeah, I'll second.
Okay.
Just a question.
Discussion.
So the text is okay?
So no one has identified anything in the text explicitly as new evidence. When we come to the PowerPoint submitted by Larry Smith, I'll take you through, there are some definitions that are pulled from other codes that,
I'm just referring to this one.
yeah,
The letter's okay.
well, the reason that I'm talking about the two in contrast is Ms. Butler's letter does include definitions taken from Merriam-Webster's dictionary. And so here, Planning Commission could choose to reject those definitions as well. I'm not recommending that you reject those definitions because you have the ability to take official notice of things that are facts that are commonly understood, and dictionary definitions fall within that scope. However, I do not believe that definitions from other codes fall within that scope, because those definitions are particular to, the way that city has determined what grading means or what. So a general dictionary definition, I think you could take official notice of and need not reject. You could, in an abundance of caution, decide to reject that as well.
Okay, any other discussion items? Okay, all those in favor to support the motion? Unanimous. So it was first by Commissioner Edwards, second by Commissioner Borowski, unanimous. So we'll move to the second.
Great, thank you. And then the second piece of testimony is the PowerPoint submitted by Larry Smith. And on pages 4 and 5, I'm going to walk you through all of the pieces that I think are new evidence. On pages 4 and 5 of the PowerPoint, they include some definitions of excavation and grading from various codes and Wikipedia. And I recommend that the Planning Commission reject those. On page 6, there are three maps. The old topo map, the one titled Old Topo Map Misleading, is not currently in the record. The other two are. So the recommendation is that Planning Commission reject Old Topo Map Misleading. On page 7, there are 2 photographs, neither of which are in the record. The recommendation is to reject those. On page 10, there's a new photograph titled Randy Lane Stormwater Retention Pond that is not already in the record. Recommendation is to reject. And then, so those are the pieces of new evidence that we identified. There are also arguments included within this submission that are outside the scope of the appeal issues identified by the appellant. But I don't believe Planning Commission needs to affirmatively reject the arguments. You just don't consider them because they're not related to the appeal issues identified. So the new evidence that I just outlined for you is what staff believes to be new and would ask that the Planning Commission reject.
So can you help me out before a motion is presented? Do you want the motion to actually include something about the arguments not being considered, or just the rejection?
I think just the rejection of the evidence.
Okay, perfect. Commissioner Borowski.
So I have a question about a couple of the photographs that are in there.
Sure.
So if if there's reference to what is seen in the photograph in the record on several occasions, there, i.e. the Hawkins Lane and how it was, I mean, it was brought up by the applicant's attorney. It's in the record about that being made when the road was being done. And so, to me, I don't know, could that be considered in the record? Because there's several references to it, and now he's just clarifying what is in the record with photographic evidence.
Nick, can you go back to the definition of evidence? It's a good question, Commissioner Borowski. I think the answer is no. To me, a photograph that has not already been placed into the record is a document, data, or other information offered to demonstrate compliance or non-compliance with the standards. I think that it is, given that the fact that those issues are already discussed in the record, you can certainly base your discussion and decision-making today on the information that is already in the record. But my strong recommendation is that you not take into consideration new evidence that was not placed before the hearings official. And I think a photograph is a pretty good example of new evidence that was not placed before the hearings official.
Can I, but in that case, or other information, I mean, everything that was testified to is other information, right? I mean, so if somebody testifies to something that makes reference to something that's in the record.
So there's a difference between evidence and argument, and it's not always as clear as we might like it to be. But kind of on the opposite ends of the spectrum, evidence is new information that the hearings official did not have, new maps, new photographs, new, concrete information that wasn't available to the hearings official. Argument is looking at that concrete information that was provided to the hearings official and talking to you about why the hearings official misinterpreted it or should have applied it differently, or why the hearings official got it right or got it wrong. And it's my opinion that a new photograph really is new evidence. Arguments about existing photographs would constitute argument and would be okay.
Okay, would anybody like to make a motion?
I would move that the Planning Commission reject the new evidence that was submitted by Larry Smith for the record,
Outlined by staff.
outlined by staff.
Anybody want a second?
I'll second.
Thank you. Discussion? Okay, all those in favor? All those opposed? Okay, it's 3-1.
Thank you.
And you have the motion by Commissioner Edwards, seconded by Commissioner Fragla. We have a small group, so maybe I won't repeat it. You guys can follow it.
We'll ask you if we didn't get
Okay, thank you. That's great. So we'll move it. Do you have any final concluding comments?
No, I think I would just reiterate that you have heard and seen some arguments outside of the appeal issues identified by the applicant. If staff sees Planning Commission's discussions sort of start to veer away from the appeal issues identified by the applicant, we'll let you know. But generally, you should only be considering the appeal issues identified by the applicant.
Perfect, thank you. So next, Nick is going to basically, once again, using the draft final order. It is not finalized. Nick's going to use that to kind of help us follow through the appeal items. So Nick.
Thank you. So if we need it, we can pull this slide back up if you need to talk about something. This one, you're going to recognize a lot of this stuff from the last presentation, but hopefully it helps. You've seen the evidence slide.
That's fine. We talked about that, yep.
So let's go right on to appeal issue number 1, which boils down to the hearing's official erred by imposing condition number 15, which prohibits development above 900 feet in elevation, which ends up impacting lot 36. And I'm going to go to the next slide here. There's lot 36. And then within this issue, there's really two issues that are brought up. One is that the applicant is arguing that either condition 15 should be deleted because the code standard does not apply, because their argument is that this property is not subject to the South Hill study. And the second part of their argument is if you retain condition 15, it should be amended. If the 900-foot limitation in this standard can be applied, the language of 15 is too broad and should be clarified.
So I should have clarified, this is similar to how we've done it in the past, is that we'll take straw poll votes as we move through and a final motion at the end. He will vote on the subsections. So why don't we start with what is considered 1A, and any questions for staff?
Oh, you go.
Commissioner Edwards?
So my question, and you'll have to forgive my naivete on this, but this is because this would apply to clear and objective. In a discretionary tract, development above 900 feet would be allowed. Is that? So the reason that it's that development over 900, because there's development well over 900 feet in this whole area. So I'm trying to understand that it is in fact because it was clear and objective tract that they chose.
Commissioner Edwards, yes. So in this case, the clear and objective, we're still, for the moment, calling the needed housing tract for tentative PUD applications, includes a criterion of approval that says for sites that are located within the boundaries of the South Hill study, they have some extra approval criterion that they need to meet, including 12A, which provides that there will be no development above 900 feet on lots that were not in existence as of August 1st, 2001. Here, the hearings official determined that Lot 36 was not in existence as of August 1st, 2001. I'm getting the dates right? Okay. And so determined that development above 900 feet is prohibited. That same criterion of approval is not included in the general track. So, and applicants have the ability to choose whether to proceed under the needed housing track or the general track. It's totally up to the applicant. In this case, applicant chose the needed housing track, and so that criterion applies.
So I do understand that, but I just wanted to make clarification because I was not understanding why there was development above 900 feet, but that couldn't be on this particular application. So that does help me.
Great.
Thank you.
Great. Commissioner Borowski?
Yeah, I guess if you can walk me through your memo on why the applicant's argument isn't valid as far as the annexation and all of those.
So Commissioner Borowski, the applicant here under this appeal issue is arguing that this criterion should not be applicable to this particular development site because at the time that the South Hill study was adopted, this development site was located outside of the city limits. And so even though the boundaries of the South Hill study were not super well defined and included areas outside of the city limits, at the time the study was adopted, and still, the city really only has land use regulatory authority over properties within the city limits. So at the time South Hill study was adopted, the city could not apply it directly to this property because it wasn't located within the city. The applicant is also arguing that no government entity since, whether it was the county while the property was in the county or the city once the property annexed into the city, has directly, adopted something directly applying the South Hill study to this property. There are a couple of responses to that issue. First, these arguments are substantively similar to arguments that you considered already for the Capitol Hill application. And For that application, Planning Commission determined, or affirmed the hearings official's determination that the South Hill study did apply to that particular property. My memo that you're referencing argues that the South Hill study became applicable to the property at the time it annexed into the city, just like other city land use regulations did. But this, I think, in contrast to Capitol Hill, which was a general track discretionary application where the South Hill study does apply directly to that property, because this is a needed housing application, we're actually looking at not a direct application of the South Hill study, but this particular code criterion, which is only activated for properties that are located within the boundaries of the South Hill study. The boundaries of the South Hill study are all properties south of 18th and above 500 feet. This property is south of 18th and above 500 feet.
500, yeah, right.
So it is located within the boundaries of the South Hill study. So that triggers then this needed housing code criterion that says no development above 900 feet unless you were in existence as of August 1st, 2001. And no one has argued, the applicant has not argued, that the city's code does not apply to this property. So if, even if Planning Commission had questions about the direct applicability of the South Hill study to this property, if you can find that it is located within the boundaries of the South Hill study, south of 18th, above 500 feet, and, that's all you need, then this criterion does apply.
So when Capitol Hill went to LUBA, they didn't look at this particular thing because another section of the hearings official's decision kind of made it moot, as I recall. So if we affirm the hearings official's decision in this one, and the applicant were to go to LUBA, would they look at this to give us a final answer on it? Because again, I don't feel comfortable as a planning commissioner, again, I think this is one of those ones that's kind of above my pay grade, to decide. So do you think that would be something that would be looked at, or would they skip over it again?
The reason that LUBA did not reach the question of the applicability of the South Hill study in the Capitol Hill appeal was due to the kind of interesting procedural posture of that appeal. I can't guarantee what this will look like. It depends in large part on what the applicant does in their appeal, but I think there's a good chance that LUBA would be able to get to the question in this one.
Thank you.
Commissioner Edwards and then Commissioner Fragala.
So I just had a question because in reading part of the record, there is an issue of whether, I'm going to try to find it, I apologize, that the state law says that it should not apply. Can you speak to that?
So I think what you're referencing is there is a statute that the applicant brings up. It's located in Chapter 215 that talks about when a property is annexed into a city, county land use regulations continue to apply until the city directly applies its own land use regulations. And the applicant, I believe, is citing that statute to kind of bolster its argument that no government entity has ever taken action to directly apply the South Hill study to the subject property. I think my staff's position is that doesn't matter, because whether or not the South Hill study applies directly to this property is not really a question for the Planning Commission. The question is whether the property is located within the boundaries of the South Hill study. And if it is, then the needed housing criteria, which is a code criteria, which the applicant has never argued doesn't apply, applies. Does that make sense?
Commissioner Fragala.
So going back to what Lauren just stated, I do think that the property is south of 18th and above 500 feet, and therefore that is what we're being asked to decide, and that this code criteria does apply. I would also, I think I take some issue with the idea that once property is included within the city limits, that we don't apply code or laws or regulations. I mean, once it's in the city limits, you're in the city, right? And we have a structure of governance for that. We shouldn't have to go through and tick off every little thing to ensure that our code of governance applies. So I personally agree with the hearings official's decision on this one section. I do have some questions going on to B, but I will save those for when we get to that piece.
Okay. I have one remaining comment. I agree with Commissioner Fragala in terms of really the boundaries of our decisions today. And I mean, no pun intended, that actually it's within, this property is within the boundaries as described by Lauren. We talk about this a lot, so, and I know it's currently being resolved. I do think there's some interesting arguments on behalf of the applicant. I mean, one of them is the South Hill study. These refinement plans are quite old. So there's some kind of inherent challenges if we're actually following policy from areas at a certain adopted time and things change, right? So that's all I have to say. So are we ready to take a straw poll vote? Okay, all those in favor? Oh, sorry.
Need a motion?
That the hearings official did not err. No, it's just a straw poll vote. That this hearings official did not err on this item, that the South Hill Studies applies to this property. All those in favor?
Just on A.
Just on A. We're talking about just 1A. Okay, all those in favor? Okay, 3. All those opposed? Okay, 1. 3 to 1. Okay.
Just want to mention, if you guys could speak up, apparently it's not being
Oh,
recorded very
know,
loudly right now.
I will do
so
that.
We're trying to work on that, but
Okay.
in the meantime,
Perfect.
speak loud.
Okay, thanks for the reminder. Okay, we'll move to 1B. And Nick has already outlined it, so questions? Commissioner Fragala? Okay,
Yeah, so I'm curious about if, I'm assuming that in this deliberation, we need to be working within the constraints of our current code and, current legal direction, policy direction. I am curious, though, that once we have new code in place for clear and objective, what would be the applicant's ability to bring this back? Will it always take it out of being able to be developed if the code changes? Does that make sense?
I'm going to look to planning staff.
Yeah. Nick, do you want to answer that? You want me to? Okay. So in this case, they're subject to the standards that are in effect when they applied. If those standards subsequently change, what this particular property would be entitled to do is go through a new planned unit development under those new standards.
Commissioner Borowski?
So they would have to go through a whole new planned unit development application.
Correct.
So I'm just putting hypothetical out here. This planned unit development gets approved with conditions, but lot 36 is the lot that is in question. Subsequently, if, as she stated, if the conditions change and they just wanted to develop lot 36, would there be a route for that to happen or not?
The route would be
Going through a whole new planned unit development.
It could be a PUD just for that particular lot.
Then the second thing is the applicant felt that a different wording and condition might be appropriate for that. Can you talk to how his wording would jeopardize the hearings official's decision? It's basically, he says, applicant proposes an amendment amended condition that would state, this tentative plan unit development approval does not authorize the development of a dwelling on lot 36. The applicant contends that there is no bias for, oh wait, no, wasn't there a, I thought there was a proposed condition from the applicant that said,
I think what you just read was the proposed
Attachment
condition.
E, maybe?
So, Commissioner Borowski, I'm looking at page 4
yeah,
of the appeal statement.
right,
And I believe what the applicant is proposing is a condition that would state, they said something along the lines of, quote, this tentative plan development approval does not authorize the development of a dwelling on lot 36.
right, and then just stop there.
Yep.
So can staff talk about how, if that would be,
Sure. I mean, there's a couple of things. Just, I mean, if you go back to the relevant criteria, which is on page 3 of the final order, it says no development. So it doesn't just single out dwellings. It says no development. So there's that piece. But it says no development shall occur on land at an elevation of 900 feet, above 900 feet, except that you can get one dwelling for that lot in existence. So there's a couple issues that we've found, and the hearings official found with this tentative, or with this proposed condition, is one, it just would provide flexibility that's not afforded by that criteria. One, it would allow additional types of development, and two, it doesn't, what did we write in here? I'm sorry, I'm trying to lost my place. It doesn't include exemptions, like that particular criteria doesn't include exemptions for future development or development of any other type of structure. It's not open-ended. It is, that criteria is very clear, no development above 900, and that's how we need to treat it in this PUD.
And that is the applicable criteria now. It's true that there, at some point, the code may change. You certainly have spent a lot of time looking at proposed changes to clear and objective standards, but that is still working its way through the process. We don't know what council will do. And the application needs to be reviewed under the applicable criteria now. And as Alyssa said, that criterion is very clear, no development, and there's no sort of until such time as it's just no development.
So I'm going to put myself in the queue. I have a question. This is something I wish I wanted the applicant to do. So I'm going to ask, is this within our capacity under the current circumstances? And that is with the understanding, of course, that there's the option of a new PUD. This is very specific to Lot 36, so kind of continuing from what Commissioner Borowski brought up, is there a way, and this is a question, to add something to that condition that allows that flexibility for that site, that just says something more blanketed? If there's a change in code, 36 being able to follow that code standard. Does that make sense? So it basically allows some flexibility within the current decision with the context that this is current discussion occurring, right, on a sideline legislative process.
I understand what you're getting at, Commissioner Taylor. My recommendation would be not to do that. For a couple of reasons. One is that I don't think it makes any difference to what the applicant would be required to do once the code, assuming the code is amended to allow development above 900 feet, the applicant would still need to file a new PUD application. So, talking in the condition about how that's a possibility doesn't actually change anything on the ground. And it just has, the possibility is that, the wording of the condition will be interpreted in a way that we didn't intend. that it will be interpreted not to be consistent with the applicable code criterion. The condition that was imposed by the hearings official, I think, is consistent with the applicable code criterion. It does what the code requires now. And if the code someday changes, the applicant can come back based on that new code and ask for something different. But that's up to the applicant to do.
So one follow-up question, it's probably the same answer, I'm just still kind of exploring. Is there anything within the confines, which I understand clearly what you're saying, really where it's this, and once again, I wish it was better addressed, is that essentially you've got this giant tentative PUD, right? And you've got one lot. So it sounds like there's really no other mechanism or tool to basically allow for something less significant than an entire resubmittal of an entire tentative PUD.
I'll look to staff, but I don't think so. Janessa pointed out, however, that the applicant could right now submit a discretionary PUD application for that site or the entire site, and this code criterion would not apply.
So it could be specific to just that one site, and
I believe so.
okay, thank you. Any other questions? Okay, Commissioner Borowski?
Not so much a question, just a statement that this is great information for moving forward with clear and objective standards revisions, since situations like this are what we're trying to resolve in that type of clarity. To me, this one is a poster child for a reason as to why that needs to be, one, moved forward, and two, looked at very carefully, because unintended consequences always spring out of writing code, and so take that to heart and know that we need to be judicious and careful, but also move forward hastily. Thank you.
Okay, can I get a straw poll vote that the hearings official did not err on appeal item 1B? All those in favor? Okay, it's unanimous. So let's go to appeal item number 2. Nick, are you, sorry, I just want to make sure you weren't waiting for me.
Yeah.
to say it. Perfect.
Appeal item 2 is the hearings official erred in applying the 40% common open space requirement. And deals with the issue of basically what we think common open space should be versus what the applicant has proposed. And I think we covered it in the last presentation, so I don't know what else there is to say about it, but pretty
Okay.
thorough.
Do you have the slide available that, because I don't think we have that in our packet, that delineates the common open space as opposed to what we see on this map?
Yeah, it doesn't show up very well, but
I
you
can see it. Thank you.
kind of see.
It's the hatched area.
Yeah.
And so this is another criterion applies because the property is within the boundaries of the South Hills study. So it's criteria 12C, which is on page 5 of your agenda item summary. And on page 7, the top of page 7 is the condition that was imposed by the hearings official. So again, the applicant had the same argument about whether or not it was subject to the South Hills study. And then their second argument was about whether or not it was actually a clear and objective.
Okay,
Procedural question.
yeah, hang on one second. Commissioner Edwards. Yeah, okay, Commissioner.
So I'm just curious, are we going to rediscuss every time whether or not it's within the South Hills study, or is that just going to apply all the way through since we made a decision on that?
That's a great question. We've already made a decision, so I would say that, no, we don't need to rediscuss it unless anybody has concerns about that. Okay, thank you. Thank you. Commissioner Edwards.
And I just want to mention, just kind of for the record, I am struggling to be convinced that the South Hill study would actually apply. I mean, I feel like.
So your vote is the
So
same?
my vote, well, not, I mean, that's the challenge that I'm having, because then having to apply that. But I did just have maybe some general comments about the 40% common open space. Does not seem clear and objective if people are under the assumption that they could expect public access. I think that the thought that the private property has to be available for public access is outside, to me, the scope of what for public enjoyment would be. And I can, there's a lot of different examples that I've seen of very open spaces that don't have fences or structures and everything else, but they're not necessarily intended to be hiked on by the residents. It's just more of a view, an open view or whatnot. Wildlife can, kind of come and go. But but yeah, so I feel like my vote, I can put aside the struggle that I'm having with applying the South Hills study to this particular site. But then even beyond that, I think that's kind of where I'm at with that.
Okay, Commissioner Borowski?
Again, so you can refresh me, but I think I'm pretty clear on this. We are not in the position to decide whether or not a standard is clear and objective. If it's in our code, again, correct me if I'm wrong, but if it's in our code and it hasn't been remanded to us by a higher governing body, then we are to assume that it is clear and objective. We don't have the decision at this level to decide whether the appellant's argument that statement is not clear and objective. Is that correct?
So can I put that in context a little bit? So the city attorney's office's advice from my office has consistently been that the planning commission cannot ignore or choose not to apply code provisions. That is the effective equivalent of amending or repealing a code provision, which planning commission doesn't have the authority to do. Only the city council has the authority to do that. This question comes up in the clear and objective context most often because applicants will ask you to find that a code provision is not clear and objective and therefore cannot be applied, and so then ask you not to apply a code provision to a particular application. I think which then would be the equivalent of amending or repealing that code provision. So it puts you in a tricky situation. I think, and my recommendation is that we have to assume that since our code criteria were adopted by the city council, and we have a needed housing track, that the council thought that they were clear and objective and has chosen not to amend or repeal them to date. Maybe they will in the future, but not now. So unless Planning Commission hears from the council or a higher authority, LUBA, or a court, that a particular code criterion is not clear and objective and cannot be applied, then Planning Commission does need to apply that code criterion to an application.
Okay, so for me then, on this appeal issue, there's two things that the applicant has asked. There's one, does South Hills study apply? And we've got a 3-to-1 vote that yes, South Hills studies applies. And then two, the appellant is asking us to, if it applies, then it's not clear and objective. Again, moot. I can't, by the city attorney's recommendation, it's not our position to do that. So then the only thing I think at this point that we really have any purview over would be the condition that was set by the hearings official as far as what can be not built on those lots, which is condition number 12, right?
16.
Or 16?
Yeah.
So am I right in kind of,
I think that.
would you agree with that?
I generally would agree. I think that the question before, as I would frame it, the question before the Planning Commission is not whether the criterion is clear and objective, but rather whether the applicant or the application satisfies the criterion. And the hearings official determined, I personally think did a nice job of looking at the criterion, deciding, that it means use or enjoyment, and that can mean just visual enjoyment, and then imposing a condition of approval to ensure that the application would comply with that code criterion. If the Planning Commission agrees with the hearings official, you could simply affirm her decision. If you feel like more or something different is needed out of that condition to ensure that the application complies with the approval criterion, you could do that. You could decide that you disagreed with the hearings official's interpretation of the criterion, that you think it means something different than she think it means. That's all within your purview, but not applying it, I would say, is not within your purview.
Do you have a comment, Commissioner Fraggle?
Yeah, so I actually think the hearing official was very generous in their interpretation of the 40% common open space. And, initially on my reading of it and after the public hearing, when I was thinking about it, I felt like she may have been overly generous, but after going back, I think, one, there are very specific definitions that are provided throughout the documents, and two, when you read that wording where it says, or, I know from teaching contractions to my students that or implies this or that. It doesn't imply both. So I can agree with the logic that she applies. I do think she was very generous. And because of the or in there, I do think it's appropriate that that residents not have physical access, but they are getting the visual enjoyment from it. But based on the definitions that she also included about fences, I agree with the condition that is being applied, because I do see a fence as a structure which would interrupt this visual enjoyment. So I agree with the hearing official's decision based on the definitions provided and on the use of or.
I want to put myself in the queue. I think the hearings official on page 32 of her decision, I think she's pretty clear. Physical access is not explicitly stated, and it is or. And as she said, while visual enjoyment may be minimal and may be of little value as an amenity for residents, the express language only requires only enjoyment and does not define the scope of that enjoyment. So I do think she was quite liberal, actually, and the 3 or fewer common open space areas, I think, is quite liberal, because I look at it and I'm like, she wasn't super clear. I went through it, how she actually defined it. She was very good at defining everything else, but she made differences between the site and area, but didn't explicitly talk about 3 or few areas. So unless staff has a clarification on them finding something in the record. But anyway, so I think that I can support the condition that she has. I do agree that I think if she was quite generous. Yeah. Commissioner Borowski.
I'm almost there. The only question that I would have is, as far as, I understand she defined fencing and buildings as, anything that's erected or joined together. I guess my question would be, what about natural features? Would it be possible for people to plant rows of arborvitae along there? Would it be possible for them to put in big landscaping rocks? If you've got common open space, but every lot has 2 rows of 20-foot arborvitae on each side, would that be allowed?
So,
Because, it wasn't clear to me, and the idea of that this is, if it's gonna be open space, an area for visual enjoyment, to me, that could limit that. And so that's why I'm just wondering if I could get across that.
yeah, so let me take us back to the
Yep.
criterion. So what the criterion provides is development shall cluster buildings in an arrangement that results in at least 40% of the development site being retained in 3 or fewer contiguous common open space areas. For purposes of this section, the term contiguous open space means open space that is uninterrupted by buildings, structures, streets, or other improvements. And so the hearings official looked at, in terms of the fences question, looked at the definition of structure and said a fence is a structure. So I'm going to clarify in the condition of approval, no fences.
It's the other improvements that would landscaping be considered
Another improvement.
That's kind of basically what it gets down to.
Do we have a definition of improvement, Alyssa?
We don't have a definition of improvements. We have a definition of site improvements, but not of improvements.
Again, another reason to rewrite clear and object.
If that was a concern for the Planning Commission, I suppose you could amend the condition of approval to add in, she already has that language, actually. So the hearings official's condition of approval says the final site plan shall include a notation that the deeds of each of the 21 lots designated for common open space on the site plan shall include a restriction that the designated open space shall be uninterrupted by any buildings, structures, streets, or other improvements, including fences. So she just called out fences for clarity, but that would still be within the definition of structure, and must be available as a visual resource for the enjoyment of all residents of the development. So I think, and this is going on the deeds of each of the lots. So if some of the residents of the PUD felt like one of these property owners was doing something with their property that constituted another improvement that prohibited their visual enjoyment, or did something else that prohibited their visual enjoyment, her condition also requires that the deed restriction be enforceable by the city, all of the lot owners, all of the residents of the PUD individually, and if there's a homeowners association, the homeowners association. So the folks in the PUD have an avenue to challenge things that might happen within that common open space that would interfere with their visual enjoyment based on this condition.
I understand that. I just don't understand. To me, if you put up something that is not visibly enjoyable to me, and that is an other improvement, it just seems very unenforceable if it's not a building or structure. And that's why I was asking if plantings or natural things were included. And again, I'm not real clear. I don't think it's enough to dissuade me away. I just wanted it to be brought up. Again, this is an area that we need to look at when we're moving forward. things, I buy a lot in this thing, in this development, and think, this is gonna be beautiful, and it's gonna be, I'm gonna see from lot number 27 down to lot number 14, because that's common open space. And then I have a 20-foot arborvitae hedge right next to my property, and I don't like arborvitae. So now I've got to get a lawyer, and I've got to challenge this, and it's one person's interpretation against another. So again, to me, it's squishy. I think that they meet the code criteria by the way that the hearings official said it, but I'm going back to, this is another area that is subjective.
You might prefer some different code criteria.
Okay, any other questions? Okay, so we already know 2A. It has to do with the South Hill studies. We've already made that determination. So 2B, all those in favor that the hearings official did not err in applying the 40% common open space and including her proposed condition of approval. All those in favor? Okay, we'll move to number 3. So as you know, 3 has a lot of subsections, so we'll just take them section by section.
Yeah, the issue number 3 is the hearings official erred in applying the 20% slope grading limitation. And within that, there's
Can we
5 of
just
them.
take, yeah, just go one by one, Nick? So talk
So-
about the first one, we'll do a straw poll vote, and
First
go to the
one.
next one.
Deals with a burden of proof not met for excavating only on lot 29 was, in essence, what the argument was. And lot 29 is the lot, I'm going to go back. It's the lot right there, right here, that you can see that does not have frontage on Randy Lane. Its access was to be provided through an easement here in red between lots 26 and 28 that came up to the bottom part here of 29, and then this yellow area is greater than 20% slope, which then brings you to an area here. Although it has wetlands, it's unprotected wetlands, so a house could be located here. And that was the issue that we had, that you have to, in our opinion, you need to grade a driveway and not excavate it. And the applicant thinks otherwise. So the hearings official ruled, I guess, in the context of what staff was arguing, ruled in favor of that, and then came up with a condition to combine lots 28 and 29, which we'll get into in the next one of the other sub-issues. But the first argument is that she erred in ruling that you couldn't get to that building site without excavating only for the driveway.
Lauren?
So in case it's helpful to the Planning Commission, all of the sub-issues under Appeal Issue 3 have to do with the criterion that prohibits grading on slopes of 20% or greater. So it may be helpful to do a little bit of discussion about what that criterion requires, what staff and the hearings official determined the applicant did or did not show. And then, so let me back up. So we have this code criterion that prohibits grading on slopes of 20% or greater. As you know, there was a recent Planning Commission decision that was approved by or affirmed by LUBA on a separate South Hills PUD, where the applicant in that, the Furtick PUD application,
Which was also needed housing.
which was also needed housing, argued, so this criterion did apply to that application, argued that excavation is not the same thing as grading, that the 20% slope criterion only prohibited grading but did not prohibit excavation. And Planning Commission agreed with the applicant, and the applicant in that case was proposing to dig out holes for piers, for housing to kind of be on stilts, I think. Cantilevered, thank you. There's a better term for that. And then also proposing to dig out utility trenches, excavate utility trenches. And so in the context of that application and in the context of the land use code, which does differentiate between excavation and grading in the definition of development and in a number of other places throughout the code, the Planning Commission said, yes, we agree excavation is different than grading, and the 20% slope criterion only prohibits grading. LUBA agreed with the Planning Commission and adopted specific definitions for grade and excavate taken from the New Third International Dictionary. LUBA said grade means to reduce to an even grade, whether on the level or in a progressive ascent or descent, whereas excavate means to hollow out or to form a cavity or a hole. So bottom line, the staff received information from the applicant where the applicant said, we're going to do things like develop driveways, develop home sites, but we can do that by excavation rather than grading. So on slopes that exceed or 20% or greater slopes, we will be excavating driveways, we will be excavating home sites, we will not be grading those things. And staff said, and the hearings official agreed, that the applicant had not provided the city with enough information to show that that is a possible thing to do, that development on slopes of 20% or greater could be done solely by excavation and not by grading. Then the hearings official imposed 3 conditions of approval to make sure that the 20% slope criterion was complied with. The first was to combine lots 28 and 29 to ensure that in that combined lot, there was enough area that was not 20% slope or greater that would allow that combined lot to be developable without any grading on slopes 20% or more. The hearings official also imposed a condition requiring an easement for a driveway to lots 2 and 3 to make sure that that driveway didn't encounter slopes of 20% or greater. And the hearings official imposed sort of a blanket condition on the entire development site, generally echoing the criterion, just saying, look, no grading on slopes of 20% or greater. So that's kind of what is before you now. There's a lot of discussion about whether or not the 20% slope criterion is clear and objective. And my understanding is that's not really the question. The criterion itself is clear. The criterion says no grading on slopes of 20% or greater. LUBA said it was clear. They've said it's clear a number of times in a number of different decisions. And they even identified what constitutes grading and what constitutes excavation, which is something else. So the question that I believe that's really before the Planning Commission is not whether the criterion is clear and objective. I think it is. The question before you is whether the applicant has supplied you with enough information to be confident that they are not going to grade on slopes of 20% or greater. And if the answer to that is yep, I think that they have shown me that they will only excavate on slopes of 20% or greater, then the criterion is met. If the answer is I agree with the hearings official that the applicant has not provided the Planning Commission with enough information to determine that there will be no grading on slopes of 20% or greater, then your options are to say, well, the criterion is not currently met, deny the application, or, as the hearings official did, condition the application to ensure that that criterion is met. So that's my kind of overarching thoughts.
Questions? Commissioner Edwards.
So then, I guess, based on the applicant's understanding and understanding that there is a difference between grading and excavation, I'm struggling with trying to figure out what would having them adequately demonstrate other than saying, we're not going to grade, we're just going to excavate. We know what it means, we know the difference. What would that have needed to look like?
Yeah, I'm going to turn to staff for that one.
Okay. I mean, do we see this in other applications where they show something, or I mean, is it?
I don't think we've had this kind of argument before for
Yeah.
other applications, but I think when you're looking at terrain on a piece of paper, you're not
Yeah.
seeing the undulations that are there. You're just seeing topo lines, but the ground probably doesn't look exactly like that. There's dips and bumps and rocks
Right.
and whatever's in the way. You have to go in and scrape all that out. That's what we're calling grading. So you would have to demonstrate to us, and perhaps there was an area on there where there had been a slide at one time, maybe. And the ground was perfectly flat, but just on a slope. Could they come in and say, we could excavate that and make a driveway? Maybe that's possible, but they didn't show us how to do it other than the examples they provided, which showed what looked like a subdivision somewhere on some relatively flat ground and they showed a driveway. It looked like a driveway had been there, had been pulled out, and was going to get repaved again. That's what they showed us in a picture. I think what we were saying is that's not adequate. So we don't know what adequate would look like until we see it.
And if they were to be able to provide what would be considered adequate under the understanding of what grading is versus excavation, then they theoretically wouldn't have to combine those lots. But I just don't know where they would, at what point in that process, they would have to appeal just to be able to submit some sort of evidence or proof, because it's not in the record. And so I guess that's where I'm kind of trying to figure out what the course of action would be. If in fact they didn't show specific engineering plans or whatever else as to how they're going to excavate these driveways on this particular site and within this driveway easement, where would they be able to do that in this process? Would it be only on like an Aluba appeal?
So can I add before you answer it? Because actually I had the same question. I want to elaborate. So the hearings official on page 9 of her decision, she actually agrees with the applicant that the proposed PD does not propose any houses or driveways. Development standards relevant to those improvements are not subject to review under this application. So there's actually an inherent kind of challenge, right? Is that it's a level of detail that actually the hearings official agrees it's actually really not part of the PUD. Yet you have this criterion that's asking for something. And you're not exactly sure how to get that, right? So it's an interesting situation. So the extent of which, what's that burden of proof and what does that look like considering those circumstances? So in some ways, when I look at this and I look at it as her third condition of approval is relevant. The other two, I'm challenged by, because if at the time of development or the final PUD, and right now I don't have, I think the final PUD, you have to actually demonstrate you're meeting the conditions of the approval of the tentative PUD, and maybe that's how we condition it, and that's where I want further discussion about that. It's that she's ensuring that they're meeting it in a way that's assuming they can't excavate, yet she's also saying, oh, this isn't the time necessarily to be proposing these things. So I guess I like the third one. Basically, yeah, you can't do this if you grade. And granted, it does bump that burden of proof to the stage of development, which per this she's saying is appropriate. So that's where I'm challenged a bit. So staff, yeah, it's just adding to, yeah.
So those are good questions. I think this is maybe another instance where we would prefer the criterion said something other than it did, but we're stuck with the criterion that we have. Chair Taylor, you bring up one of the arguments that the applicant made, which was, but actually did not pursue on appeal, which was the proposed versus, the criterion said proposed grading, and they're not actually proposing any home sites or driveways as part of this PUD.
Yeah.
I will say that's not one of the Peel issues that's before you. But what the hearings official said was, that's true, no individual driveways or home sites are being proposed as part of this tentative PUD. However, if there are areas of the site that cannot be developed without, moving through 20% slopes, then this criterion still applies, because at some point, you're going to want to develop those lots, and we got to figure out a way to make that possible without grading on slopes of 20% or greater. And I think she focused in on lots 28 and 29 and lots 2 and 3 in particular, because those were also lots identified by staff where it simply wasn't clear how you could access those lots and or place a home site on those lots without moving into areas of 20% or greater slope. So that's kind of the first piece. And then the second piece is, so once you're in the area of 20% or greater slope, are you grading? If you're grading, that's prohibited by this criterion. If you're excavating, it's not. But she was of the position that what the applicant had provided, which was more than this, but effectively a statement that, we'll excavate, we won't grade, was not enough for her to feel like there was evidence in the record to show that the criterion had been met. And so her first two conditions of approval guarantee no grading on lots 28 and 29 and lots 2 and 3. And then the third was more of a general umbrella condition, understanding that there are other areas of the site that are 20% or greater, and upon which grading would also be prohibited, but they don't stand out in the same way that those particular lots did as undevelopable or inaccessible because of the 20% slope. Do you need to do the same thing that the hearings official did? No, but that's my understanding of why she made the decisions that she made.
Yeah, I mean, that's clear. And actually, once again, I think she's quite creative, and actually, to some degree, really the burden of so do you think the only other option would be to deny it? Well, because where my concern is, she's giving an option, but what if, for instance, in the lot 2 and 3, what if actually they can get across with just excavating? That condition now limits them unnecessarily.
I will say, and staff, please correct me if I'm getting this wrong, but my recollection is that the applicant actually proposed both of those conditions as possible conditions. Is that true?
Definitely the 28, 29.
Yeah,
It was 2 and 3 also.
Yeah, they brought that up as a possibility.
Okay.
Okay.
Well, that's good. I didn't remember 2 and 3. Okay.
I mean, that was, just to put it in context, the applicant has always argued that this criterion shouldn't apply, that they can excavate instead of grade, but I believe in sort of a belt and suspenders approach, they also propose some of these conditions to ensure that the criterion was met, and I believe she took them up on them.
Okay. Thank you for the clarification. Commissioner Brodsky.
So for me, a couple things came out of this one. One is the hearings official and staff felt that there wasn't enough evidence put in there, and I disagree with that. I think that the evidence that was presented by the applicant, by a professional landscape architect and their firm, showed grading, showed excavating, and the hearings official made claim that it didn't look like it was on a slope, but at the public hearing, they said that the picture that is depicted is at a 20% slope. So to me, there is enough evidence in the record to say that they can prove that they can do this type of development with excavation. We opened the door when we said excavation isn't grading at FERDIC. So that door's open, and it can be used. For me, it's absolutely appropriate on lots 2 and 3, where the definition that Luba gave us for excavate is to hollow out, form a cavity, or a hole in. That's a berm that was created by the creation of a road. I see berms hollowed out all the time, and a cavity created for roads, for driveways. So to me, it absolutely fits the definition of hollowing out, and it makes absolute sense that that's where the driveways should be, coming off of Hawkins. You hollow out by excavating. So on this one, for me, I am absolutely on board with the applicant's arguments that they can develop these properties by excavation. So that's where I'm going to be leading on these votes. I think there's evidence in the record. Staff didn't agree with it, but that's where it's our decision to either say yes or no, that evidence proves to me that yes, these can be done by excavating. So that's where I'm at on this issue.
Commissioner Fragla.
And I guess I would have to say that I didn't feel like they provided enough evidence. And so when you say they could excavate through the berm, so, I mean, what are we imagining? Are we imagining like giant walls of earth going up on both sides of the driveway? If they have to cut through this terrain, it just seems to me like that's not, I mean, yeah, maybe they could just excavate through, but it doesn't seem to me that given the terrain, that it's likely there will be no grading. So because of that, because I don't feel like I've been convinced by the applicant that they wouldn't have to grade, because I can't understand how they could do this only by excavating, given the terrain. If we were to make the decision that, like you said, on lot 1 and 2, maybe it is permissible that they excavate the driveways through. I don't think that same logic applies to 29. And I would want to make sure that the condition that enforces the no grading is included if we're taking their word that, yes, they can excavate. But I don't believe they did provide enough information, given the terrain, that they could only excavate. So.
Commissioner Edwards.
Just one comment. I agree with Commissioner Borofsky largely. I do believe that the applicant provided a clear understanding of the difference between grading and excavation, which to me demonstrated that they understand that that's the difference and that this is what we're allowed to do and this is what we're not. And so I do believe that they did provide, that the necessary evidence that they could do that.
So I have a couple questions. So one, I don't think, first it's my role to decide what grading or excavation, how they're going to construct these sites. So, I am looking for evidence, and basically they did provide information saying we're going to excavate these, and it's possible. We don't have contextual information for the site. I don't like the criterion because it is, in one case, I don't want to need to repeat what I said. So I look at what we have in front of us, and really where I'm going to and want to kind of get staff's advice is that, yes, we've got a clear criterion. It's been identified in the record that this might be a little premature to be starting to propose construction documents for driveways and access. I'm not sure. It seems like to me you're saying the record didn't clearly say, the applicant didn't clearly say in one sentence, there is no proposed grading on any lots that have a 20% slope. So is that where they're falling short? Because in essence, they are kind of saying that by the bulk of their submittal, right? So with that said, is there a way to get it a condition, because condition 3 is general? Is there a way, and it's basically the burden, and I want to say the risk, so watch out for what you ask for to some degree, they also proposed, so I'm kind of caught, because if they propose both of those conditions, 1 and 2, as an alternative, I also don't want to eliminate that alternative potentially, but if they're saying, we're going to excavate, I want to trust that and say, okay, number 3 is generic, there it is. And if you can't, once again, just like the 900 feet, you've got to go through another tentative PUD potentially to modify the proposal. So I guess help us out in terms of what could conditions look like? What are your thoughts on what I just said?
So I think, Chair Taylor, in terms of your first question about, what would the applicant need to say, I don't know exactly what the applicant would need to say, but I think my interpretation of staff's position, and they can speak for themselves if I'm getting this wrong, and the hearings official's position was what was articulated by Commissioner Fragola, that this is a difficult site. Everyone has sort of acknowledged that to be true. And given the terrain of the site, the hearings official just felt like the applicant had not met its burden to show that development of the site could happen without grading ever on areas of 20% slope or greater. If Planning Commission disagrees with the hearings official and feels like the applicant has done enough to meet its burden, and has said, and I would agree that the applicant has said, we will excavate and not grade, then, yeah, and then I think the question comes back to Planning Commission for whether conditions 1 and 2, the combination of lots 28 and 29, and the driveway to lots 2 and 3 are necessary, given that the applicant is saying that the applicant can do that work without any grading. My recommendation would be to retain condition 3 as a kind of overarching condition that effectively repeats the requirements of the approval criterion, but also explicitly makes it a condition of approval for final PUD that the applicant, again, that there can be no grading on slopes of 20% or greater. But theoretically, if Planning Commission feels like, well, the applicant has completely met its burden and will not, we are confident that there will be no grading on slopes of 20% or greater, that's what the approval criterion requires. You could say the criterion is met.
So do you mind if I add 2 follow-up? One is, do I feel like maybe I want more information? Yeah. Do I feel like that condition number 3 satisfies it? Yes. Meaning, basically, there is the affirmation that there won't be any grading, right? So the condition actually forces that satisfaction, right? So I do want to, my second part is I want it with the caveat that I think staff's suggested change of language, I agree with that. Yeah. So that's all I have. Any other questions? Commissioner Brodsky.
I kind of agree with what you say, but I'm concerned about condition 3. So, if we're putting condition 3 in there, we're basically saying that they're going to excavate, right? That's kind of what I heard from the chair. But then it says here, the final site plan shall provide the city with the detailed plan that demonstrate that no grading will occur on any slope. So again, that leads to somebody at the city interpreting grading and excavating.
Commissioner Brodsky, if I may, so that what you read was the condition number 3 proposed by the hearings official. Staff is proposing a slightly modified condition of approval.
Where can I find that?
It would be, it's at the very end of the draft final order. all of the
also
conditions
on-
are listed.
Page 14 of the.
What number
order.
is it on the?
It's number 3.
Oh, boy. Yeah, it is. You know what? I didn't, that's a typo, and the final order will have a typo for condition number 3. I didn't make
Oh,
our proposed change.
I'm sorry.
So it's going to be on page 14. I'm glad you just pointed that out.
Page
Yeah, so it's at the
The top of page
page
14.
14 of the draft final order. And so it says staff's recommending amending condition number 3 as follows.
So the condition number 3 recommended by staff is that the final site plan shall include a statement that no grading will occur on any slopes that the tentative site plan depicts contain slopes equal to or greater than 20%.
So they just say, we're not going to, a statement.
The statement is, yep, we won't grade on slopes 20% or greater.
So then that is not reviewable by permitting staff?
Well, so that's a good question. So when the applicant then comes in for building permits, and I can turn to Janessa, who knows a lot more about this, but my understanding is that building permit staff does look at the, final PUD plan and would look at those conditions and would look at what the applicant is proposing and say, is it excavation? Or is it something other than grading? Because grading is prohibited. And that would be the basis upon which permits would be issued.
Okay, so again, so that gives me, a little bit of pause because we don't have what definitions is permitting going to be using? What criteria is permitting going to be using?
Well, so, do you want to take? No, go ahead.
Are they going to be using the same one as we have here, hollow out, dig, and that has been affirmed by Luba, or is there some other criteria that permitting is going to be using? Because, again, in our thing, we say, yes, give us a statement, and you've got a tentative PUD approval. But then he takes his building permit in, and the inspector says, nah, that's grading. What is the redress from the developer on that type of a situation?
So the condition is, should Planning Commission decide to impose the condition is imposed to ensure compliance with the criterion. We know what grading means for purposes of the criterion. Luba has told us it's,
Yep.
moving dirt versus digging out dirt, basically. So when that final plan comes in, I imagine that building permit staff would take that into consideration. I know we also have things we call grading permits. We have, so that, that's about all I can tell you.
So for me, I think that condition is moot, because if they meet the condition, we're saying that they're meeting the condition by not doing grading. So why do we, or they're meeting the criteria, If we say grading, that we feel that they can meet the criteria with grading, why are we putting a condition in that says they have to tell us that they're meeting the criteria?
I think one of the things to think about too is that we've just been focusing our conversation on driveways, but at somebody's going to buy one of these lots, they're going to come in, they're going to want to put a home site somewhere. So this also acts as a flag for them to know in the future what the limitations of the lot are.
That's a good point. We don't know that the PUD applicant will be the developer.
Right. Okay.
My experience, this is fairly common. It's stating, it's assurance.
Redundancy.
Yeah.
Assurance.
It's just so it carries forward.
Commissioner Fragala, did you have something?
So I'm hearing my colleagues say that they feel like the combination of lots 28 and 29 and the access, the right-of-way to 1 and 2, that the applicant has demonstrated, and so that those don't need to apply, but that that we are leaning towards including the third one. So I'm just curious, when we look at the actual draft, are we taking them in order? We have A, B, and C, and so is A number 1, is B number 2? I mean, so is A, I'm just kind of trying to, we said we were starting with A, right? But we've had this broader conversation. So how does the broader conversation apply?
We'll
to A,
get,
B, C,
we'll-
D?
so
Okay.
Lauren had made a suggestion to have it broad due to, which I think was a very good point. In
Yeah.
fact, a lot of my comments, I was going to suggest that. So now let's go to straw poll vote for each of them. So we'll return to our kind of procedural straw poll vote. Does that answer your question?
And I would
Yeah.
start with one, like, issue or sub-issue 1, she erred in finding that the applicant had not carried its burden of proofs. And those.
So looking at it by sub-issue rather
Yeah.
than A, B, C.
Yeah.
Well, in ABC, it's a little, some of those overlap with the other sub-issues, and some of it, the way it was structured, it wasn't 100% clear if those were under 5 or if those were redundant. So Nick structured it under number 5.
Okay, so we're going to look at it as sub-issues.
Yeah.
Yes.
Okay, great.
And-
That's more clear to me. Thank
Okay,
you.
great. Are there any other questions before we move to straw poll voting? Okay, actually, Nick has it up, so we can follow it this way. It is, we're starting on page 8 of the final draft order, and
Yeah.
in case you wanted to reference it. So let's got a straw poll vote that the hearings official did not err on the burden of proof not to meet, that's like a double, burden of proof not met for excavating only on tax lot, on lot 29. All those in,
So if I may.
yes, please.
Clarify a little bit.
Yeah.
The,
Or should we,
She erred.
right.
yeah,
so
but that, then we would all vote up, we'd all. oppose it.
We could frame it either way.
Yes, either way.
Given the tenor of the discussion, my
Flip it.
suggestion would be to flip it. So
Great.
if I can.
Of course, go for it. I was
So-
going to do that, and then yep, I think it's a great suggestion.
The, so the sub-issue number 1 is that all those who agree that the hearings official erred in finding that the applicant had not carried its burden of proof to show that lot 29 can be developed with a driveway through excavation alone. So you disagree with the hearings official's finding that the applicant had not met its burden of proof.
All those in favor? All those opposed? It's 3-1.
Okay?
Okay, we'll move to sub-issue 2, which is page 9.
All those who, oh, I'm sorry.
Go ahead.
Okay.
Yeah, please.
All those who believe that the hearings official erred in conditioning the approval to require the combination of lots 28 and 29.
All those in favor? All those opposed? Sub-issue 3?
I have a question on this one.
Yes.
This one might be moot because of the decision that we made on the first one.
Yes.
So do
Thank
we,
you, Commissioner
even need to vote on it, or do we need to say that we feel that it is not relevant because of an earlier decision?
I think, yes.
We could do a straw poll vote.
Could do either. In this case, because we've already talked about the no development on lot 36 altogether due to the 900-foot criterion, I will flip the question again and say that all those who believed that the hearings official did not err in resolving the issue of whether the applicant carried its burden of proof to show that a house and driveway could be reached on lot 36 by excavation alone, because in this case, Planning Commission has already determined that no development is allowed on lot 36.
So I still,
Yes.
so if that, I guess, I don't know how to vote on this, because what if the applicant appeals this and the first decision that we made is reversed, but then we've got this decision here that says, you know, if it's reversed and says, yes, you can build a house on lot 36, but we've got a decision that says you can't do it because of the excavation. So,
I think your decision doesn't say it's due to excavation. The draft final order as prepared for you by staff says you don't need to worry about it because you've already decided that no development is allowed on lot 36 no matter what. If it gets appealed and Luba says you're wrong about no development being allowed on lot 36, then, I would ask that the decision be remanded back to you so you can make a decision about whether excavation or grading is allowed on lot 36. But right now, because of the approval criterion that says no development at all, it doesn't make any sense for you to make a definition about excavation or a decision about excavation versus grading on lot 36 specifically. I don't think there's an error. And in fact, it might not even require a remand because generally I think the Planning Commission's decision will be the developer can excavate instead of grade. So if they're allowed to develop on lot 36, they could do that by excavation rather than grading.
But if we don't reverse the hearings official's decision on number 3, then they wouldn't be able to do it.
I don't think that's true. She just said, I don't need to consider whether they can excavate rather than grade. She didn't say they absolutely cannot excavate on lot 36. She just said, I don't need to.
There's misleading because she basically said, I'm not making a decision here because of the previous thinking. So I actually think that is a little misleading. I think we're not making we're affirming her decision to not make a decision.
The way we paraphrased it is maybe not the best.
Yeah.
She erred in saying that there wasn't enough evidence, so wouldn't it just fall back to the 20%?
Yeah, that's what,
comment
yes.
would apply? So I don't think it would be necessary to revisit it.
Okay.
There's also something to consider as the applicant actually states it like this. The hearings official erred in failing to find that a house site and driveway can be developed on lots 36, which quite frankly is more similar. It connects it to our first straw poll vote. Okay, so does that answer your question?
Yeah.
So I like you,
paraphrase.
yes.
All those who
Keep going.
agree that the hearings official did not err by not considering whether excavation or grading could take place on lot 36 because she had already determined that no development could take place on lot 36. All those in favor? Okay.
Okay, all those opposed? Okay.
Only because of my vote on the first one.
Sub-issue 4?
Okay.
Okay. So I'm going to flip it back to she did err. So all those who feel that the hearings official did err in failing to find that lots 2 and 3 can be served with driveways constructed by excavation alone.
All those in favor? Those opposed? 3-1. Sub-issue 5?
Okay, and so sub-issue 5 contains a multitude of other sub-issues, some of which have kind of already been dealt with. All right, so 5A.
So you guys following it in the draft final order? Okay, page 11.
In 5A, the applicant argues that condition 3 is not clear and objective if it delegates to staff a subsequent determination as to the difference between grading and excavation in development of driveways and house sites. And that condition 3 is the condition proposed by the hearings official, which is slightly different than the condition that's being proposed by staff. So I think to rephrase it, the applicant would argue that the hearings official erred by imposing condition 3. The question for Planning Commission is whether you want to sort of, I guess it would be a modification of the hearings official's decision to impose a condition 3, but slightly amended to take out the requirement of a demonstration as amended by staff.
All those in favor?
Well, I have a question.
Okay.
Sub-issue 5, the applicant is arguing that it's not clear and objective. And so that's not what we talked about. I don't think that the hearings official erred that it's not clear and objective. That, again, that goes back to what our role is.
Yeah, So let me take a step back. So sub-issue 5 specifically says that it's kind of an umbrella sub-issue. The applicant introduces it by saying that the hearings official erred in failing to consider and address the applicant's uncontroverted expert evidence that houses and driveways are developed by excavating and not grading. And I think 3 of the 4 planning commissioners agree that houses and driveways can be developed by excavating and not grading. I don't know that you need to take an action on that specifically because you've already sort of addressed that issue in sub-issues 1 through 4. Then 5A
That's what I was confused on 5A.
argues that condition 3 is not clear and objective. The condition 3 proposed by the hearings official is not clear and objective. And so the question for the planning commission is, do you want to continue on with the condition 3 proposed by the hearings official? I think, given the tenor of the discussion, the answer is no, that planning commission would prefer the condition proposed by staff. And so then I suppose the question for planning commission is, do you have concerns about that condition not being clear and objective? And that was the kind of initial discussion that we had about, at least from my perspective, both the approval criterion and the condition are clear and objective. They just simply prohibit grading. So the question for planning commission is, I think, and it doesn't totally track the applicant's appeal, the way the applicant has framed the appeal issue, but I think at bottom, the real question for planning commission is, do you want to modify the hearings official's decision to adopt condition of approval 3 as proposed by staff?
Yeah, again, it was, when I saw the condition A, I was like,
No, that's a valid question.
wait a second, we're
Yeah.
not doing it. So
No, it's valid. As explained, are we okay continuing to vote? All those in favor of
as long as that's figured into the,
description?
so that when it goes up to if it goes up to a different body, that was clear that that's what we're doing. We're not voting that it wasn't a clear and objective.
Right.
Yes.
Yeah, thank you.
Okay. All those in favor? It's unanimous.
So then, sub-issue B, the applicant says if the planning commission modifies condition 3 as the applicant has requested, then condition 1 becomes unnecessary because the driveway can be excavated or the driveway to lots 2 and 3 can be excavated. I think planning commission has already addressed that issue. Sub C, if planning commission modifies condition 3, then condition 2 is unnecessary, the combination of lots 28 and 29. I think planning commission has already addressed that issue. Sub D, the hearings official erred in failing to find that a house site and driveway can be developed on lot 36. I think your planning commission has already addressed that issue. And then E, if planning commission fails to find that all lots can be developed with a driveway and dwelling, including by excavating some 20% or greater slopes, then the applicant believes that the grading limitation in the code is too ambiguous to be applied, consistent with the needed housing statute. I think planning commission has already addressed that issue. So I believe that we don't need any more straw polls on appeal issue 3. I think you have made it all the way through, and I will look to staff to see if they feel like they could use any further direction. Perhaps because staff will need to rewrite some of the draft final order to reflect planning commission's decisions on appeal issue 3, it would be helpful, to the extent that you can do it now, to point to the specific evidence in the record that you feel the applicant has provided that shows that they can excavate rather than grade.
It's the letter submitted by Sommers and Satcher Group on page.
You have a date on that?
Yeah, it's April.
May 1st. Oh, wait, no.
Separate as well.
Yeah.
It was
They gave it-
received on May 20th.
Okay,
It was stamped received on May 20th.
perfect, okay.
And it's,
Got
It was actually submitted on April 10th, or the document has a date of April 10th, 2019.
Okay.
Yeah, it's actually in the header.
I think there may be a
it's
couple of
got a
different.
stamped received May 20th.
Look at the header on that. the header on their actual document. Next page, header on the top left.
Top left.
Yeah,
Top-
April 10th.
We'll see when it was actually submitted into the
Yeah.
record, though, and use that date. Okay.
Yeah, that's great. I don't know if there's several of those documents, but that's the one
I
we
think
all
it may
are
have
looking
been
at.
submitted a couple of times.
Yeah.
Yeah, that's possible.
Okay, so we're going to go to appeal issue item number 4.
Time check?
We have 4 minutes. Let's just see what that looks like, and I'll follow up if I think this one's, yeah.
Okay, so this one is the combination of lots in the final plat as a means of reducing impacts on wetlands. The applicant wanted the ability to come back after tentative approval and combine lots as it saw fit for whatever reason, and we disagree with that, saying that the requirements in the PUD say that a final plat has to be in substantial conformance with the approved tentative PUD, and if you come back with fewer lots, then you're not in substantial conformance, especially given that nobody got to see what the final configuration would be. The public didn't get to weigh in on any changes like that, and that's what this process is for. If there's going to be changes, it should have been by now.
Any questions? Okay. All those in favor that the hearings official did not err actually, yeah, she didn't err, is that I don't know how to state this one just because I'm not sure she specifically addressed it in this language.
She did, she addressed it in her finding.
Okay, great. So it's that the hearings official did not err in her findings.
I just have a question on this. I think it's a laudable goal that the applicant is going for here. And I'm just wondering, would there have been a way to do this? I mean, could he have proposed it earlier on and had more lots and that went outside of the approval criteria?
Not outside the approval criteria. I mean, it could have been as part of the leading up to the hearing official's decision, or potentially even part of the open record period. They could have proposed something, provided findings, establishing how it's consistent, and had there been an opportunity for folks to actually review what that revised site plan looks like.
So, but one of the main things was the number of lots over 13,000 square feet, and that's hard and fast. He couldn't combine 2 lots to save wetlands that were over 13,000 square feet?
You
Or would
can,
there
I
have
mean,
been a way to do that?
There is a way to do that, because you can see on the site plan, they've already proposed lots over 13,500, but you have to meet certain standards or show how you meet those standards in order to do that. And so that would happen outside of that code requirement if we just allowed it to happen.
Okay, so this could have happened if they had thought about it earlier?
Yes.
Okay.
So do you want to, so we can be specific, the findings, the hearings official findings? I don't know what kind of information you would like me to state so that it's clear for appeal issue 4, that the hearings official did not err in her findings on page
29 of the
guess
hearings official's decision. So on page 29 of her decision, the hearings official noted that so following the hearings official hearing during the open record period, the applicant requested an additional condition that would allow the applicant to submit a final PUD that contains a fewer number of lots than are approved in the tentative, and with more lots exceeding the maximum 13,500 square feet limit in the code. And the hearings official said no, for all the reasons that we just discussed.
Okay, perfect, thank you. I was just not remembering her address at wetlands, but that's right. She clearly, yes. So all those in favor, straw poll vote? She did not err. Okay. So we have 1 minute. Are you willing to stay a couple of minutes so we can get a motion? Because that could potentially mean that because our straw poll votes were very clear. I'm seeing Commissioner Borofsky uncomfortable, but it's clear. We still can meet tomorrow.
Well, my concern is just that we made substantial changes to the draft final order, and they're going to need to be rewriting those before we vote on a final order. So I don't know if I'm comfortable with voting on a final order without having seen it.
So there's two separate items. So I think we could still have a motion and still come together and have an opportunity to review the order. So do you want to clarify?
I think the question for Planning Commission is exactly what Commissioner Borowski outlined, which is,
Okay.
Is Planning Commission comfortable with kind of making a final decision on this application, having not seen the revised findings, because we will need to make some revisions to the findings. If the answer is you would prefer to see the findings before adopting the final order, I think that's reasonable. Then I would not ask for a motion today. You'll
And then
need
you
to
would
come back
put it- okay,
together
okay.
and with that document in front of you,
Got it.
approve it.
Yeah, that makes sense. Thank you. So yes, Commissioner
My
Fragala.
question is going to be about process, and that will we then go through and deliberate every single one? Because because I understand that there will be 5 of us tomorrow, and
That's a good
so one person will not have been here for this process, so like what happens in that situation?
That's a great question. Thank you, both of you. So I'm going to defer to staff because that's a great question.
That is a great question, Commissioner Fragala. Given the votes that took place today, having the additional commissioner would not change the outcome of any of the straw poll votes. So I don't believe that Planning
That's a good
Commission would
point.
need to re-deliberate those issues. Whether or not you want to give Commissioner Baker the opportunity to kind of speak his piece about issues that may be important to him, that I think that's kind of up to the chair. And then, but since he will be present at the meeting tomorrow, assuming that he has, watched this meeting prior to tomorrow's deliberations, he could participate in the final decision to adopt the draft final order or not.
Yeah, Commissioner Borowski.
Yeah, I mean, I think it's wholly appropriate. We've had this happen in the past, back before others, where he can bring up issues and discuss, or anybody can bring up issues and discuss them, and that may sway the vote. In the past, I've seen it where, somebody brought something up that we hadn't thought about, and it was like, oh, that makes sense, and it may change it. So that is a possibility. In my opinion, if I were chair, I wouldn't say, we've got 3 1s on all of these, whatever you say isn't going to change our vote, because what he says could change our vote, at least could change mine. So I think that it's appropriate for any of us to speak until a final motion has been put on the floor.
The other possibility is that, as long as we have a quorum, if the 4 of you can return tomorrow, Commissioner Baker wouldn't need to participate if he decided that,
Right.
having not participated in deliberations today, maybe he doesn't want to participate.
Yeah, it's interesting what you bring up, because if you think about from a procedural standpoint, if we do, and what you said is valid. The only concern I have is, then why do we have the meeting today? So to some degree, procedurally, if this can happen each time, we might want to wait, knowing that you're going to have 2 potentially, and the whole process could happen again. I just want a level of, it's something we should consider in the future, because I think if that's truly the case, we might want to be a little bit more thoughtful about when and how we hold meetings. So with that said, we're here, and we've made these decisions. So, it sounds like we're going to wait. It's already 5 after. Wait till tomorrow. So our next meeting is tomorrow.
It's at 5:30 in the slow room.
Yeah. Okay. Wonderful. Thanks. Any further questions?
Does staff have enough information to move forward on the?
I feel
on the
like we do,
final order?
yeah.
Okay.
Okay. Perfect. Thank you so much, and we'll see you tomorrow.